Dear Chief Acosta, I bought a lot in Parañaque City. However, I noticed that it had no adequate outlet to the public highway. Thus, I filed a case in court to compel my neighbor to grant me a right-of-way. The court decided in my favor, but it ordered me to pay him as an indemnity for the use of his lot. If I pay my neighbor as ordered by the court, can I become the owner of the affected lot? Ganid.
Dear Ganid, no, there will be no transfer of ownership of the property affected by the easement upon payment of indemnity. Article 649 of the new Civil Code provides for the requirements of a legal right-of-way to quote,
Article 649. The owner or any person who, by virtue of a real right, may cultivate or use of any immovable which is surrounded by other immovables pertaining to other persons and without adequate outlet to a public highway, is entitled to demand a right-of-way through the neighboring estates after payment of the proper indemnity.
Applying the quoted provision of law, the Supreme Court in the case of Anastasia Kimen versus Court of Appeals, penned by the Honorable former Associate Justice Josue Belusilio, elucidated that
Right-of-way, in particular, is a privilege constituted by covenant or granted by law to a person or class of persons to pass over another's property when his tenement is surrounded by realties belonging to others without an adequate outlet to the public highway. The owner of the dominant estate can demand a right-of-way through the servient estate provided he indemnifies the owner thereof for the beneficial use of his property.
Further, in 2015, the Supreme Court in the case of De Guzman versus Philinvest Development Corporation, penned by the Honorable former Associate Justice Mariano del Castillo, explained that the payment of indemnity is merely for the use of the right-of-way and not for its alienation, to quote,
In easement of right-of-way, there is no alienation of the land occupied. Payment of the value of the land for permanent use of the easement does not mean an alienation of the land occupied. In fact, under the law and unlike in purchase of a property, should the right-of-way no longer be necessary because the owner of the dominant estate has joined it to another abutting on the public highway, and the servient estate demands that the easement be extinguished. The value of the property received by the servient estate by way of indemnity shall be returned in full to the dominant estate. This only reinforces the concept that the payment of indemnity is merely for the use of the right-of-way and not for its alienation.
applying the foregoing in your present situation, if you will pay for the value of the indemnity for the affected land, it would not mean that the ownership over the subject land will be transferred to you, because the payment of indemnity is merely for the use of the right-of-way. You are only paying for the right to use a portion of your neighbor's property to enter your property and not to purchase it. We hope that we were able to answer your queries. Please be reminded that this advice is based solely on the facts you have narrated and our appreciation of the same. Our opinion may vary when other facts are changed or elaborated. Tomorrow, we'll look into another question from our viewers and readers of Dear PAO. This is your host, Dr. Presida V. Rueda Acosta, DSD, the Chief Public Attorney of the Republic of the Philippines. Goodbye for now.